Okay, welcome everybody. We're going to do question 1, 2023 February Civ Pro. Now, for the essays and the February bar, I have not looked at any of the questions. But in the interest of full disclosure, for question 1, I did listen to a YouTube video by Apex Bar Review, and I thought she actually did a really good job of going through it. So I might have some, things in my head from question 1. But let's begin. Number 1, did the court properly deny Dura-Tyler's motion to dismiss? Well, I don't know why they're trying to dismiss it. And it looks like if I see like the 4th paragraph, which is something I just caught up by my eye, failure to join as a defendant. Okay, so wow, joinder of parties. That's an interesting topic. Number 2, did the court properly grant Dura-Tesla's motion? A, to compel production of the statement from Wynn. What are things that are discoverable and have to be produced? That deals with things that are relevant and proportional. And to compel a physical examination of Pam. Well, you're going to get a physical examination if you're, asking for any type of physical damages, which is generally the case in personal injury. And of course, if you're seeking emotional distress, you'll get a mental exam, but they're not asking about that. And number 3, did the court properly order Dura-Tyler to produce its scientific report? So the court's saying probably have a motion to compel, and the court probably ruled on the motion to compel and say, yeah, you have to go ahead and produce this. All right, let's take it from the top. And notice that it says question continues on the next page. And the reason why the examiner's did this is because recently I think this is only the 3rd or 4th essay to ever have 2 pages. And the first time they did it, so many people didn't know to turn the page that which didn't kind of make logical sense the way the call was set up. So the examiners have now done that and corrected the mistake that they had. All right, let's take it from the top. Dura-Tires manufactures and installs specially coated tires. Now, as soon as I think manufacturers, I'm thinking like, UCC Merchant, or I'm possibly thinking products liability and torts. They advertised, and advertisements are just negotiations of deal. So I'm also thinking about other subjects, even though they're not applying, because I know it's a civil procedure and we're ruling on certain motions, but I'm also getting in my head anything that I need to know or pay attention to, because you never know when it's going to show up. Because torts and Civ Pro often cross over, and there's a lot of torts and Civ, like on the MBE, how many people noticed that you had how many summary judgments or judgments that are a matter of law? And you're like, oh my God, they asked about this 9 times. Well, they could be testing totally different things and totally different subjects. Okay. Oh yeah, one last thing. I do request that everybody please put their cameras on. If you want to participate, and if you're uncomfortable putting your camera on, then I just suggest that you'll watch the recording. Thank you very much. Okay, so they advertised a scientific report, and that was the report that needed to be produced. Declared that his tires will not go flat for the first 7,000 miles. Advertised that a scientific report declared it was use of German property. Does anybody know what that is? And go ahead, like, what would that be if, in terms of the law, by advertising, hey, it will not go flat for the 7,000 miles? Anyone know what that is? That might show up later. Anyone take a guess at it? Go ahead, Marissa.
Guarantee.
Legally.
Like a warranty.
There you go. It's an express warranty. You're expressly stating that they'll be for 7,000 miles. And I bring that up because it's heavily tested on the MBE. Also, a sample or model is also an express warranty. So when you go on the iPhone store, the Apple store, and you see an iPhone that's chained up, that's actually an express warranty. Any model is an express warranty. Dura-Tyler's scientific report was created at the direction of its legal counsel and contained research on flat tire incidents involving them. Okay, so the last call deals with the scientific report. So I want to actually just think about it right now. Flat tire incidents involving Dura-Tires. Okay. So if it was created at the direction of its legal counsel, and of course, work product is anything that's created by a party or by a representative of the party in anticipation of litigation. So this could be work product. Okay, but it's an express warranty. So have they waived the privilege? I don't know. Let's see what's going on. Pam, and I assume Pam is the plaintiff, and D is the defendant. That makes sense. There we go. Purchased 4 new tires from Dura-Tires and had them installed by Maurice, a mechanic. So was Maurice working for them? Was he not? I don't know. Pam drove 100 miles and 1 tire went flat, causing Pam to swerve and crash into another car. Why does that not surprise me? Okay, so we don't know what the cause of this accident is. I mean, is it because maybe she hit a pothole? Maybe Maurice negligently installed it. And you see why I'm getting at this, because that goes to causation and motions to dismiss. So torts will overlap a lot with civil procedure. Okay, moving on. Causing Pam to swerve and crash into the car. Pam was not physically injured in the accident. Well, then why would you ask for a physical examination? So I'm not quite sure. No physical harm. And if she wasn't, oh, her car was, because don't forget, for strict liability, which is products liability, or for products liability or for negligence, you have to show either personal injury or property damage. Okay. She got property damage. Okay. So she doesn't have physical injury, but she has property. Pam gathered a written statement from the other driver, and Pam's the plaintiff, who suffered a minor injury. So that statement is also her work product, because she's doing it. I assume she's doing it in anticipation of litigation. Of course, she might be using it on her behalf. Win statement was favorable. Okay, so now she's got to disclose that. So here's the thing, like automatic initial disclosures have any witnesses or any information of people who are in support of your case, in favor of your case. Okay. And by the way, Ethan, if you don't mind doing that, I appreciate it. Pam filed and properly served a complaint in federal court. So properly filed and served, so no Rule 4 issues. No Rule 4. Rule 4 deals with service and process. A federal court against Dura Tires for breach of warranty and negligent installation of manufacture of the tires. Where's Ethan? Ethan, are you still here?
I'm here. I've sent everybody that doesn't have their camera on a message, giving them 5 minutes.
Okay, thanks. Pam was not physically injured. Pam gathered a written statement from the other driver. Witness, okay, got it. Pam Friday processor complained in federal court against Dura Tires for breach of warranty. Oh, there's the express warranty and negligent installation and manufacture of the tires. Well, unless Maurice was an employee of Dura Tires, you can't sue for negligent installation. So what the court's got to do is dismiss that claim on a motion to dismiss. But if you want to, because breach of warranty, you're going to have a hard time proving causation, though, because we don't know what happened. Like, why did the tire go flat? Was it because of defective tires? So you're going to have a hard time showing the causation, at least based on these facts. Okay. The federal court had proper jurisdiction over Pam's complaint. Okay, so they say subject matter jurisdiction, don't worry about it. Do not discuss subject matter jurisdiction. Okay. Pam alleged she suffered property damage and emotional distress. Well, there's your, property damage, emotional distress. Okay, so that would give her the right to a mental exam, not a physical exam. Interesting. It's kind of hard to believe that, she wasn't injured. I mean, because anybody who works in a personal injury firm knows, oh, my neck, it's really hard to disprove that you didn't suffer whiplash. You guys know that one. Anyone who's worked in a personal injury firm knows what I'm talking about. Okay. Juris filed a motion to dismiss for failure to join Maurice as defendant. Okay, so here's the question. Did she need to join Maurice? Is he a necessary and indispensable party? Well, Dura filed a motion to dismiss for failure to join. Hey, and I know a lot of people, raise your hand if you took the exam and you struggled with this question. Go ahead, just raise your hand right here. Yeah, I can see why. Because I have two kind of trains of thoughts here. Number one, he's not a necessary and indispensable party, because the court will just dismiss the negligent installation claim. There's a couple of roads to go down here. First of all, was Maurice an employee? Was he contracted by Dura Tires to install the tires? If he was, then they're jointly and severally liable, and therefore Maurice probably wouldn't be a necessary party. And because you just need Dura Tires because they're responsible. But if Maurice is an independent contractor, or if he was, he's just somebody else that she'd gone to, although it's weird, most people, when they buy new tires from a place, they are installed. You don't just take the tires, put them in your car. I mean, she doesn't even have a car to drive. So that's interesting discussion there. And then, So I think the court can't proceed without Maurice, but they would just dismiss the negligent installation claim, and she'd only be able to sue for breach of warranty. Which again, she'd have a hard time proving causation because we don't know if the tire went flat. We don't know why the tire went flat. Okay, all right. So they wow, that's going to be a tough one. Motion to dismiss. So that goes to call 1, and that's interesting. And then also, call 1. Dura Tires filed and properly served an answer to Pam's complaint. Okay, so the court denied Dura Tires motions. Okay, I think that was proper because I can't see him being a necessary party. Like, can they have complete relief without him? You know, does he kill jurisdiction? We don't have no information about Maurice's citizenship, whether he's subject to personal jurisdiction or whether he kills diversity. So, and that's what you go to, like, it's Rule 19 for those of you that want to look it up. Rule 19, necessary and indispensable parties. I just can't imagine him being that. I'm sure there's more to the discussion there, and I'd have to really think about it. So then they got denied, and they got, I don't think Maurice needs to be there. And I would discuss, so this is what the discussion would be. Well, we don't know his citizen. We don't know if he's going to be subject to personal jurisdiction. We don't know if he's going to kill diversity. I think they said, did they even say it was diversity? Well, it has to be. How do we know it has to be diversity? Anybody know? Anyone take a guess at it? Why it has to be a diversity case? And why it can't be anyone? Okay, the answer is there's no federal claim. The claim is for breach of warranty and negligent installation. Neither one of those are a federal cause of action. They're state causes of action. So therefore, we know it's a diversity case. And I think that connecting the dots is what the examiners are looking for here. All right, Pam served her initial disclosures on Dura Tires, but they give you the issue, initial disclosures. I mean, they just give it to you right there. But did not produce Wynn's statement. And because Wynn is favorable to her case, I assume she's going to call Wynn to the stand. In fact, one of the cool things about civil cases is the plaintiff, the first person I had experienced personal injury attorney, Mark, I forgot his last name, Mark, he used to teach our remedies class, and he said, as a personal injury lawyer, plaintiff's lawyer, he goes, the first person I would call to the stand is the defendant. And the defendant has no Fifth Amendment privilege against, well, the Fifth Amendment, the defendant must take the stand, can still assert the Fifth Amendment, but unlike criminal, they can be called to the stand. Okay. So she did not produce Wynn's statement. And, you know, for initial disclosures, you must disclose any evidence or people that that are favorable to your case. And they said it's favorable to Pam's case. They actually give you that one. I thought that was a pretty easy one. Duracell filed and served a motion to compel Pam to produce Wynn's statement and for Pam to submit to a physical examination. Okay. Well, it's interesting how they even knew about Wynn, I guess because maybe the police report. I know there's no police report here. I assume it's in the police report or somewhere. Compel Pam to I think the court's going to compel Pam to produce it because it is a mandatory initial disclosure. All right. And that's part of the discovery. And Pam to submit to a physical examination. I don't see it. She says emotional distress. Now, I did hear this from one person about the emotional distress issue. Well, she's not suing for negligent infliction of emotional distress, so that would go out the window. And somebody had like this discussion about whether, because if it was negligent infliction of emotional distress, it's not a bystander case, so then it'd be zone of danger. And if it's zone of danger, she's not, so there's still no physical injuries. Because you're gonna need physical symptoms, but not physical. So that discussion went out the window. This is why I like to go into it with a clear mind. Because that person's already skewed my judgment with saying that, which I can now figure out that it's not there. There's no way she's going to get submitted to a physical exam. That's Rule 35. The court granted both of Duratile's motions. Really? Made her submit to a physical exam. Interesting. I can't imagine why. Okay. Pam's Duratires served its initial disclosures, but not include the advertised scientific report. Okay, so this is going to go to call 3. Got it. We've got call 2 and call 1. So the first 3 paragraphs sets everything up. And then the next 3 paragraphs is call 1, call 2, and call 3. Like it goes in order. Did not include the assistant report. Pam met and conferred. Oh, so they do give you the meet and confer, which is something I've never seen them do before. They just kind of make you fill that in. And I never thought that was important, to be honest with you, because it's kind of like Customary, it's automatically known, but meet and conferred, which refused to produce a scientific report. I assume they're claiming work product. Now it wouldn't be attorney-client privilege. Well, it was created at the direction of his counsel. Okay, Ertile scientific report is created at the direction of its counsel. Okay, that could be attorney-client privilege. No, because it would be waived. So I would bring up attorney-client privilege, but it's, look, they advertised this report. So this report has been waived. I think the only issue here is waiver for call 3, which would kind of almost make sense because, as you know, call 3 is going to be the least important call. So work product, attorney-client privilege, AT Clark. Pam filed a motion to compel the court granted Pam's motion in order to produce a scientific. I would agree. So the only thing I disagree with what the court did was the physical examination. And unless I'm missing something, I don't see it. So let's go through the calls again. Did the court properly deny the motion to dismiss? And that was about failure to join Maurice as defendant. I'll be honest with you, that was, think about it. It was the first call of the question on the first essay of the day. I have to imagine that was not a good way to start it, right? Am I right? You're sitting there going, oh, shit. So, yeah, no, but then it got progressively easier there. So the compelled production of the statement from Wynn, I would assume that's a mandatory initial disclosure, and the court was correct. A physical examination, I see no evidence of any type of physical injury. So that 2B, unless I'm missing something, that seems way too easy. And number 3, did the court properly order the scientific report? I would have to say yes, and the reason is because of the fact that it's been waived. Any privilege you have has been waived. So why not turn over the report? Advertise the scientific, yeah, they advertised the scientific report. Okay, so there is my analysis going through it. We'll keep the recording going, but now let's open it up for discussion. I'd love to hear your thoughts, critique or constructive criticism, like any things that you saw that maybe I didn't see, or anything that you think I potentially missed. All right, so go ahead. Anyone got a question, or let's talk about this? Feel free just to raise your hand or speak up. Okay, no one? Okay, Marissa, thank you. I know a lot of people don't want to speak. They don't want to say things, they're a little nervous, but it's okay. It's an open forum. It's a great discussion. Let's have a discussion about it.
I just barely remember what I wrote.
It's okay.
I don't remember.
That's why we're doing it now. So Marissa, go ahead. Love to hear from you, wherever you went.
So I guess I would want to go into more about the necessary and indispensable party thing.
Okay.
Yeah.
Okay. So let's take a look at, first of all, can complete relief be granted without him there? And meaning, can Pam and Durotar, will his rights be affected here? I can't see how. So in order to be a necessary and indispensable, like here would be a necessary and indispensable party. Let me give you an example, which would make sense. You think about this. If let's say Elizabeth, I'm suing you and Andrew, like you, Andrew, and I are joint tenants, or we're all part of like a will contest or something like that, or just to say joint tenants. And in order for the court, like I say something that it was severed or whatnot, if I just sue Elizabeth and leave Andrew out, and the court's going to determine who owns the property, they can't properly do that without Andrew in the lawsuit. Because if they come in and they go, okay, Elizabeth owns the property now, that completely excludes Andrew's 1/3 right without him having an opportunity to defend his case. So he would be a necessary and indispensable party under Rule 19 in that regard. And if Andrew's citizenship obviously we have to be in federal court and state court, it's not going to be an issue. So if Andrew just, is not subject to personal jurisdiction there, well, I assume it'd have to be, because we'd probably see where the property is. It'd be in rem jurisdiction, actually. Or if Andrew was to kill diversity for whatever reason, then we would have to move it to state court. The court would dismiss it, the federal court would dismiss it, and then we'd be in state court. So we do the same kind of analysis, Marissa. Did that make sense at all?
Yeah, it did. And it's reminding me, actually, what I thought about in this exam was joinder.
Joinder parties.
Joinder parties. So
that's Rule 19, because you can join a party. You don't have to have them join, but okay, go on.
No, that's all. I mean, I just wanted to go into it more. My mind's not fresh on the rule right now.
Okay, let's do this.
Oh, yeah.
All right, so check a look. And I will share my screen real quick. There we go. Okay, can everyone see that? All right, rule 19. Everyone can see it. Ethan, Marissa, Iris, if you can shake your head, let me know, because I can only see you guys. Okay, great. A required party, a person who is subject to service of process, whose joinder will not deprive the court of subject matter jurisdiction. That means that he cannot, and that would have been the first thing I said I would have discussed, was we don't know anything about Maurice's citizenship. And we know this is a diversity case. So my first thing I would discuss is Maurice, what's his citizenship? We don't know. So we can't really make that, we can't make that a call. But if he does destroy diversity, then we have to go through another path. Okay, they must be joined if in that person's absent, the court cannot accord complete relief among the existing parties. All right, so can Duratiles and Pam, can Pam get complete relief without Maurice? Absolutely. And the answer, because here's the thing, if she can prove that the tires were defective and that was the defect that existed when it left the manufacturer, she'll win without Maurice. She doesn't need Maurice. But if she can't show causation, their Duratires are going to win, and then she'll be able to sue Maurice on her own. So I can't see how complete relief will not be granted. Let's say there was nothing defective about the tires. Duratire wins, and then she'll end up suing Maurice for negligently installing them. So the court's going to have to dismiss the negligent installation case against Duratires. Let's move on. That person claims an interest relating to the subject of the action. All right, so in the example that I gave Marissa about Elizabeth and Andrew, Andrew would be claiming an interest in the property. Here, it's not that case. Maurice has no interest in the subject matter, and is so situated disposing of the action and the person's as a practical matter may impair or impede the person's ability to protect the interest. Again, if Andrew wasn't joined in the joint tenancy thing, he would not be able to protect his interest. No, Maurice has no interest to protect. Leave an existing party subject to substantial risk of incurring double, multiple, or otherwise inconsistent obligations. No, that's not going to happen because we have two separate claims. Either the tire was defective when it left the manufacturer, or whether it was negligently installed. It's either or it's neither. And she just hit a pothole. So I can't imagine how it will impair anyone's ability. Definitely not Maurice's. Leave an existing party, that would be Duratires or Pam, subject to, okay, we got it. I don't see that. Join it. If a person has not been joined as required, the court must order the person be made a party. A person refusal to join may be made either a defendant or an involuntary plaintiff. And here it would be a defendant, but we have no refusal to join. If a party objects to venue and the joinder would make venue improper, we don't know that. When joinder is not feasible. So now we have to go down this path after we discuss subject matter jurisdiction diversity, and the fact that they're not necessary. So when joinder is not, so let's assume that Maurice kills diversity. If a person is required to be joined, then that's part A, the court must determine whether the action should proceed or should be dismissed. Okay. The extent which a judgment rendered in Maurice's absence might prejudice Maurice or the existing parties. I see no prejudice. No, there's nothing there. Okay. So I think let's do this. Stop share. I'll be honest, Rule 19 has not been tested since 2001. It's only showed up one other time in the last 25 years. Think about that. So I can understand why people would have trouble with it. And I have actually don't recall ever seeing it on the MBE. And then don't forget, because I think it would be, because it's too subjective and it's not objective. It's not either, well, because you still have to go through, even if they kill diversity, you still have to go through the other problem. So that's why it hasn't been on an MBE, and it does make it more sense for it to be an essay. So Marissa, did that help? Did it help people to kind of go through that we looked at it and understood like how they could have relief? If you didn't, please raise your hand and let me know. Okay. If you want to move on, we can move on, but I'd rather have, I know a few of you have questions and you're afraid to ask, but don't be shy. This is a time to discuss it. Going once? Did that help Marissa, by the way?
Yes, that did help. Yeah, I need to go through it again, but it is helpful. So yeah.
Okay, is there anything else that I can address for you to make it easier?
Just going through the first part of the Rule 19, I need to go through it again. But I do appreciate the breakdown on the necessary and indispensable parties and how it would affect the case and whether it's feasible. That part I get. I think it's more.
Well, I mean, does Maurice have anything to protect in this lawsuit? Does he give a shit what happens?
I think not as of now.
No, he doesn't. As of ever, Maurice doesn't care, because if she's able to prove it's a manufacturing defect, he never even has to be bothered by this. And if it's a negligent, if Duratiles is able to prove that the defect did not leave, there was no defect on the tire when it left its factory, and then it must be the case that Maurice negligently installed it, or it was Pam's fault. In that regard, Maurice is just going to end up being sued by Pam if he did negligently install it, and the case against Duratires will be dismissed for lack of causation, or even lack of any defect. Now, if Maurice is an employee of Duratires, well, then he doesn't need to be joined anyways. So every angle that I take, I don't see how Maurice is a necessary and indispensable party. I just don't see it. How did anyone who took the bar kindly let me know how you went about it, please? Haley? Good, Arsenal.
Bless you. So as I remember in the during the exam, I wrote that if this tire company needs him, the Maurice, to be as a co-defendant, he instead of filing this motion, he can file. They can file the motion to add him as a third party, like a co-defendant.
And
So
plead
they
him?
can do that. Yes.
They're not asking about him pleader though.
No, as a suggestion that they could do that instead of filing this motion.
I would disagree with that. Did anyone else see him pleader? I don't see him pleader because now if he was an employee, actually, no, Arnson, you make a good point. If he was an employee, then he can be pleaded. But that really doesn't.
That's I'm trying to say that if in this case they can plead him as a co-defendant if he was some kind of responsible for and was an employee of the company, but they filed this motion and it should be dismissed.
Well, okay. All right. Anybody else? Thank you, Archie. I appreciate that. Does anybody else have anything to add, or should we move on to the worst one of the day, from what I understand? Going once? Going twice? Okay. Ethan, if you don't mind, could you stop